Thank you, Your Honor. So I represent the town of Auburn and the town of Auburn's interim town administrator, Mr. Daniel Boone, who's here with me today, as well as the chair of the board of selectmen who has been named as additional defendant in this case. I just want to point out a couple of facts here. By offer of proof, there's going to almost certainly be far more than 500 ballots cast on Tuesday. The number 500 was taken from a March local election. In the past 2 September primaries, there's been closer to 1,500 or 3 times as many, and that has been in cases where there are particularly competitive primaries, unlike this year when the primaries are particularly competitive. And so we would expect at least the 1,500 ballots that we have seen in 2018 and 2020. I think it's also important for the court to understand that we're talking about 1,500 people voting on 26 races, which means that if you're going to hand count, you're looking at hand counting over 20,000 votes. This is not an easy effort. This isn't something that can be done in an hour or 2 hours or 3 hours. This would take a substantial amount of time, a substantial amount of effort. Is not prepared for. It's particularly the case because some of these votes involve voting for the top 3 out of 4 candidates. Those types of elections are particularly time-consuming in order to count by hand, which is why the town of Auburn does utilize a ballot counting machine. Now, while the town of Auburn does utilize a ballot counting machine, it had been determined prior to this case being filed that there would be a hand count box. So for the town of Auburn at least, there is going to be a box in which anybody who wants to have their ballot hand counted, including the plaintiff, Mr. Richard, doesn't need to put his ballot into the machine. And if Mr. Richard and 5-10 other people decide that they want to put it into the hand count box, the town of Auburn will be hand counting those in the hand count box. Final point I just wanted to make is that Auburn's machines have been tested, they have been calibrated. The town clerk, Kathy Silva, was present during the calibration and the testing, and that happened just a couple weeks ago this past August.
All right, Mr. Richard, any rebuttal?
Yes, sir. To cross on the last attorney, I apologize.
Attorney Tierney.
Attorney Tierney.
That's right, I have all the names written down here.
By what standard was this testing, and this is part of my complaint, there are no standards in place for certification. Now, my expert witness didn't testify, but I can tell you, and the reason I had the photographs entered into exhibits is that they were initially UL certified when they were manufactured for safety. That's gone. As soon as they opened the box and started tampering with those devices, and they've never since updated their certification. So when he says they're testing and certifying and doing these various things, there are no standards. And who wrote the standards? If what exists was written by an unelected body. The Ballot Law Commission cannot make law. But in this case, the legislature did grant 656:42 that it has the power to do that. Unfortunately, that's a whole other subject. But the point is that there are no standards. I want to back up a second. And the Attorney General's office talked about that there won't be a problem with hand counting versus machine counting, and that being an option. Sir, I was denied the right to vote. I went to my town on my primary day and went to my supervisor of the checklist, gave him my ID, said, I'd like my ballot, please. Just handed my ballot, and then asked where I can deposit in the hand count box. I was told that that wouldn't be an option, that if you wanted to vote, there was one way to do it, and you use the electronic machine over there. I voiced my protest. I went to the moderator, filed my protest with him, and then followed up with the attorney here, and who was very helpful and said, look, we were following directions from the Attorney General's office. They've instructed, and that's part of the exhibit, I think, D in my filing. They instructed the towns, ignore the Constitution and follow the statute. That's what they instructed them to do. That's what they've instructed them to do. Ignore Mr. Richard and ignore his concerns until the court tells you otherwise. So here's another problem that we haven't talked about with machines. Violation of the Equal Protection Clause of the 14th Amendment by allowing some towns the discretion to decide whether they want to adopt a device not approved by amendment, and I'll get to that in a second, and then allowing some towns to do it, others not to. That's not equal application of the law throughout the state. The state legislature makes law. Why didn't the legislature say, hey, we're going to use electronic devices? Because see, I don't oppose machines. Matter of fact, what I'm opposed to is violating the procedural due process to achieve that outcome. Let me give you an excellent example. Absentee voting comes to us in 1942. This is part of my case. 1942, prior to that, there was no exceptions for absentee voting. How did that come to be? By an amendment. They proposed a yes or no question in 1942. The people said yes. From that period on, we had absentee voting. Same thing in 1957 with for the main election. 57 for the primaries. Rinse and repeat, same situation. The state proposed an amendment, the voters said yes, and now we have absentee voting. Okay? So I would say, I'm not against the machine. What I'm saying is that if you're going to change, and by the way, the state said that I was claiming that I misinterpreted Part 2, Article 32. I didn't misinterpret Part 2, Article 32. We have 200 years of usage and custom. Prior to 1979, there was no electronic device. Everyone counted by hand. That's what we had. So the fact of the matter is the statute did make that change. Is the statute constitutional? That's what I argue in my pleading. The state, by the way, has opened the door to my expert witness because he was citing the testimony from that report. And I would ask that if he's opened the door, then my expert be allowed to testify. To continue from there.
Your Honor, I object to that, Your Honor. I took the expert report under notice, said that you had read it. I would read it again. Referring to content there, that is absolutely fair content here, but there's no mandatory testimony, nothing about anything that I said changes Your Honor's determination as to the consideration of expert testimony and also the consideration of the court review of record advisement.
All right, I'm going to stand on my prior order, or I'm going to take a look at it and read it and understand it. And I've read codes before, so.
Daniel,
I'm almost done.
can you ask for a minute?
You're on it? Yeah, please.
We're done with the evidence portion. We're just an argument. If you want to take 2 seconds and talk to him, go right ahead. I'll give you an opportunity. Where's the evidence for no injury? Provided any evidence that they're injured by doing this by hand, that there's some kind of injury. Again,
What is the de facto if we have a challenge to the vote we can count? So, they can get producing areas. Using.
While we're there, let me ask you a question. Are you, it was unclear to the state, I thought it was clear to me, that you're just asking me to enforce an injunction against the town, not statewide.
Well,
Because you did serve the Secretary of State and the governor.
I did, Your Honor, because it all originates from that office. It all originates from the
My
legislature.
question is, who do you want me to prevent the voting machines to be used next Tuesday?
The town and the state,
Okay, so everybody.
everybody.
Thank you.
Getting away with it since 1979 should not, just because you've been getting away with it doesn't, I don't think that flies well in this courtroom if people try that argument. The Ballot Law Commission can't make law. This entire use of this device revolves around an entity that cannot make law. 656 statute, 656:42 has assigned those duties to the Ballot Law Commission. So that's who the towns are applying to here. They're not applying to the legislature. They're not applying to a body authorized to grant them the use of the device. Who is the Ballot Law Commission to say, we're going to ignore the previous usage and custom for the last 200 years, and we're going to adopt these new devices? And the whole thing is shady. Like I said, it began as a temporary use authorization, and they did nothing about it, especially after they had adequate notice back in February to start dealing with these issues and preparing for the upcoming elections, because they knew the upcoming elections were coming. And on that point, the Attorney General's office is concerned enough that it is now hired, or I don't know if they're hired or just people that volunteered. Other attorneys are going to sit in the town of Wyndham, Bedford, and Laconia. Why? Because there were serious anomalies in the counting and the way the vote, the election was done in total. So if there isn't a problem, they're clearly concerned about it. And so what did they do about it? They didn't do anything legally as far as changing the law or changing the statutes. And again, putting any standards in place. Certified. Oh, evidence equipment. I want to refute what the AG just said, and that's what the sidebar was. One additional piece of evidence, if the court would allow me to enter into evidence. This is the ballots and the hand count from the Wyndham event showing overvotes and discrepancies in the system and how it works. So these are copies of the tapes and the outcomes from Wyndham. Your Honor.
Sure, but I thought your preliminary request was based on work like safety.
It was.
That's
I'm just
geared
repeating.
towards the merits of whether or not these are reliable machines in the beginning.
And so having said
Unless I'm
that.
misunderstanding your request for preliminaries,
Yes.
a bit focused on that.
Yes.
Okay.
And that's really the whole point of today's hearing is to, again, with all the attention focused on our elections, what's most important, I think, to everyone in this room, there cannot be a question as to the integrity of this coming vote. Because it's no way to start the primary season to continue the chaos that we've had for the last 2 years. Whether you agree or disagree with the outcome of the last election, what is irrefutable is public confidence. That's why there's a commission. Public confidence nationwide is now in doubt, and we've got to make sure. And that's why I think that the court should issue this injunction. Hand count, no one gets hurt. We preserve the integrity of the primary while we set another hearing at another time to work out whether they should be abolished completely. But that's what I'm asking you to do today. Thank you.
All right. We've given me enough to think about. Response?
Very brief.
I normally let him go last.
Excuse me.
Brief, because I normally let him go last.
Just identifying the plaintiff, I don't think understands the operation of administrative law, Your Honor. He keeps on citing to the Ballot Law Commission and how they're unelected and establishing protocols or standards. The regulations that he cites to, the CFRs, those are federal regulation. Those are exactly the same circumstance. He finds authority in the federal version that he agrees with or thinks applies here, but doesn't in the operation of New Hampshire administrative law. And then you made a reference to poll inspectors and election monitors. Your Honor, those,
Those have been going on for decades.
yes,
They've had the
both of
election,
those programs there.
election department
It's,
going on forever.
it would be a misrepresentation to say that those are based on anything unique about the ballot counting devices, operation or safety of the ballot counting devices. Those are the operation and administration of elections in those three different jurisdictions.
Okay.
Thank you, Your Honor.
I'll be very, very brief.
Did they teach you to say that in law school?
Yes. Regardless.
You didn't take my class then.
Regardless of what may have happened in past elections, at this election coming up this Tuesday, the town of Auburn, where Mr. Richard wants to vote, will have a hand count box.
Mr. Richard, my practice isn't always to give the person with the
Thank you.
the last ups.
I'll
I'm
try
like you're the
to-
home team in baseball, so.
I'll just close out with this since you touched on the ballot law commission. Your Honor, 65640, 65641, 65642. Those are the three statutes that all govern and control the use of this electronic device. But in the end, what's ended up happening is the legislature has delegated powers of all three branches of government to that body. It now has a judicial power. So 656:40 allows them to make law because they're allowing the towns are applying to this commission as to whether they should use a machine. The next thing is 656:41 is the police power. They granted the ballot law commission police power because who's the one examining these machines? A bunch of people who've been nominated, most of them are attorneys with no background in electronics. How can they be examining these devices to see if they're even suitable to be used for elections? 656:42, same thing. There is the power to make law. That gives the ballot law commission to make their rules and enforce them as law. And then finally, in 1982, they gave them judiciary power. They now possess powers of all three branches of government. And this is a big problem. And so I'll close with that, so thank you.
Thank you very much. All right, I'm going to take this matter under advisement. I will I'll probably issue an order within 24 hours. So you give me a busy day tomorrow to kind of get through and sit through all this stuff, do some research. Is there anything else that folks would like to submit? If you're going to submit it by tomorrow morning at 9 a.m., because that's when I'll probably start drafting my thoughts on paper. Okay?
Thank you.
All right, thank you all. All right.
Croc TV.